Three little words. Three little words are going to determine whether or not the case against AG LETITIA James will go forward. And those three words aren't "I love you." Kelly and I are going to break that down. Hi, I'm Melba Pearson, also known as the Resident Legal Diva, and I'm here with Kelly Hyman, and we are going to break down what is happening in the LETITIA James case. However, do not forget to like, comment, and subscribe to Legal AF for all things at the intersection of politics and law. So, as we well know, charges have been filed against New York Attorney General LETITIA James, which accuses her of lying to lenders in order to get a better rate on a second home. And the indictment against her also alleges that she rented said property, which would be a violation of the terms of the loan she got. However, as all good attorneys know, the devil is in the details. And the detail includes a second home rider. So apparently, this addendum to the mortgage contract, which is standard, and Fannie Mae and Freddie Mac uses this rider regularly. It basically requires the lender to maintain exclusive control over the occupancy of the property, including short-term rentals. So the whole jam behind this is to make sure that the second home, and how it's being used, is it being used as an investment property? And if so, who is in charge of it? Is it some nameless corporation management company, or is it an actual human being? And so they were trying to dissuade bigger corporations from kind of getting into this game and getting better rates and basically, making more money on top of money versus the average person who just may want to rent out their second home in between vacations or whatever the case may be. But the three little words are including short-term rentals, meaning LETITIA James, the AG of the great state of New York, was explicitly allowed to rent the place out periodically as long as she stayed in charge of it. So, Kelly, thoughts? Woof!
Short-term rentals. What exactly does that mean? And what is the court going to do about that? So, from the legal standpoint, we would say that this is a contract, and the court, being the judge, would in fact interpret the contract. What exactly does that mean? And if so, was in fact she violating the agreement, or was she able to rent out the place? And therefore, what does that have to do with this case? Well, could potentially make the case go away. What are your thoughts?
Oh, I think it's a wrap, because as soon as the judge sees that, where's the prima facie case, right? Because if the whole case hinges on the fact that she was not allowed to rent out this place because, she didn't disclose it to the lender, whatever the case may be, and now there's clear evidence per the same contract that was used for the indictment that says she's allowed to rent it out as long as she maintains control over it, there's no case. That's the end of it. The judge should dismiss it. And, not only to mention that, if you dig a little deeper, there hasn't really been any record of rental payments. So even if the allegation is she rented out that home, well, where's the rent money? So it still goes back to point A, that this is a politically motivated stunt and not based on any actual crime or evidence that's been uncovered. And it was just Lindsay Halligan, who is the interim U.S. attorney, in Virginia, who brought this case forward, is just answering to her higher power, the president, versus actually exercising prosecutorial independence, looking at the facts, looking at the evidence, and understanding why the U.S. attorney right before her was like, no, I'm not going to file charges because there's no charges to file here. So
the counter argument to that would be that Miss James received a benefit from the interest rate based on the fact of how the property was in fact presented. And so that would be the argument that, in fact, she did receive a benefit. Another potential argument from the prosecution standpoint would be, okay, if it allows short-term rental, but what exactly is a short-term rental? And is a short-term rental 1 or 2 months? And would argue potentially that it doesn't qualify for a short-term rental based upon the facts or circumstances that someone's been in there longer or whatever the definition of a short-term rental would be. I could see them, and I'm sure they probably would make additional arguments as well. But those are the first two that come to my mind about arguments that they would make to counter that if in fact the court determines, yes, this does apply. And in fact, short-term rentals, what exactly does that mean?
Well, it's interesting that in the indictment, Halligan has alleged that AG James used the house as a rental investment property, renting the property to a family of 3. But that would be permissible, at least how I'm reading what the second home rider provisions are. So basically it says that as long as you maintain exclusive control over the occupancy of the property, including short-term rentals, then you're fine. And also, as long as you're not giving a management firm or any other entity or person control over the occupancy or the use of the property. So again, if the contract is saying she's got to maintain control over the property, that seems to be the case here. And they also have not seemed to bring or at least point to any kind of rental agreement. I think they only found based on A.G. James's 2020 tax return, there was $1,350 in rental income, which was paid to allegedly cover the cost of utilities. So again, if you're saying she had this rental property and got this whole benefit and everything else, well, where's the benefit in terms of the rental income, right? If she's letting somebody live there for free, that's not exactly a benefit per se. And, most importantly, even if the person who was occupying the property, which was her grandniece, even if she did pay rent as alleged in the indictment, that alone is not enough to say that there was criminal fraud here. So, that fraud, the fraud issue is one that the prosecution has to overcome beyond a reasonable doubt. And I don't think they have enough here to do that, especially since the rider was signed and clearly at the time of her getting this mortgage, she's saying that, I'm going to use the second home as a second home, not my primary residence. And so that means the mortgage company was well aware of her intentions at the time of setting that mortgage rate. So they can't say that they were defrauded. I mean,
it'd be interesting to see if there's another part of the agreement is because the documents are numerous pages that potentially could contradict that statement about the short-term rentals or something where the prosecution would hang their hat on, so to speak, to say, okay, even though this says short-term rentals, there's another part of the agreement that lays out another position to help substantiate their case as well. But going to your point about the high bar, it's important to remember that there has to be intent. And what that means is that Miss James must have that specific intent to defraud. And so I think that that's really important to think that that's a pretty high burden, because the harm of just bringing cases where, in fact, there isn't the intent is disheartening, because we go back to what the prosecution, they must prove the case beyond a reasonable doubt, but then also not only believe that they have to have a conviction, that they believe that they can sustain that conviction if the case, in fact, is appealed. So that's a pretty high burden. And with specific intent, I wonder what exactly are they going to have to prove that Miss James had the specific intent for fraud.
And that's where I think they're going to get stuck like Chuck, because the reality is, if the contract says, because it's all in the four corners of the contract, that is the beginning, middle, and end of the evidence. What is in the contract and what did she do? If she governed herself according to the contract, which was, hey, as long as you maintain control, whoever stays up in the house, no biggie, and that's what she did, then there's no case to be found there. Now, again, if there was some other shady something, she had an offshore account, something, okay, well, bring the evidence. Let's see what you got. But again, in noting that the previous U.S. attorney basically got fired as a result of not bringing charges because he didn't see the evidence, and other folks in the office were like, there's not enough evidence here. That's telling me, Ms. Halligan, you're not going to have a good day in court. Not at all. No, ma'am. Mm-mm. But that's my humble opinion. Kelly, you get the last word.
Ultimately, on this issue, the court will decide. And if in fact they decide that the four corners of the document help substantiate the defendant's case, then potentially this case could go away. As of right now, the case is on the rocket docket, as we say, and is set to go to trial in January. So we'll have to provide people with updates of what's going on and what happens with this.
And trust and believe we will be doing that right here at Legal AF. So make sure to like, comment, and subscribe. And I'm Melba Pearson. That's Kelly Hyman. And thank you for tuning in. Take good care. Bye.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.